5 minutes.
Thank you, and Director Grewal, like I said in my opening statement, we want to see more of you, not less of you. I will note to the chair that, yes, the chair of the SEC was in front of this full committee in October. Look at what's happened since October with the rulemaking, the number of proposals, et cetera, and unless there's some secret plan to make sure he's in September, he's not going to be here, maybe not even for the rest of this Congress, so that will be over a year since we've seen the director. So, I'm sorry, since the chair. So, Director Grewal, concerned about a couple of things, and I'm going to try to hit this quickly. Unprecedented attempts by the SEC to slip drastic market-changing interpretations of securities laws into otherwise routine enforcement cases, and two, the lack of internal consistency when it comes to the SEC's own ideas about basic foundational elements of market regulation. In a recent case, the SEC, rather than relying on decades of existing case law and legal precedent, presented a case in which it defined a, quote, dealer as, quote, any business that purchases and sells securities for its own account, close quote. So if I'm interpreting this correctly, it quite literally means that every market participant in the country, which means under the SEC definition, regardless of their business model or current regulatory regime, they would somehow now be subject to a widely different and inappropriate, in my opinion, regulatory framework. That quickly, overnight. So, and that's not all. At the same time, in the same SEC, there's a controversial proposal underway in which the SEC is attempting to dramatically expand the definition of this core term, dealer, but this time, a wholly different manner than how your enforcement team defined the term. So two different definitions being presented by the same SEC are in fact wholly inconsistent with each other. So it seems to me that the SEC is frankly brazen about it and thinks that it can rewrite the most basic of the elements of securities law whenever it wants to fit whatever purposes it needs at the current moment, with no regard to the effect on markets, the economy, or even internal consistency. And you know, I'm a guy from Michigan, so I think in car terms, all right? This is a little like we're asking people to build a car, but we won't tell them what the speed limit's going to be. We won't want to tell them what the car should or shouldn't do, what the safety products ought to be on it, but we're going to determine that later. And we're just going to mail you a ticket for speeding. Well, we've got a responsibility to set speed limits and or then to make sure that there's a consistent approach and application of that. So could you please illuminate me, you know, what is this approach?
So thank you for that question, Ranking Member. With respect to the enforcement action that you referenced, that's a litigated matter, and we're confident that our position will survive scrutiny in that litigation. We've succeeded in other courts.
How about the inconsistency of it?
I can't speak to the rulemaking that's being done by the rulemaking divisions, and I think it's in a different context, so I'd refer you to my colleagues in those divisions who are responsible for that rulemaking.
Well, if we could get them here, I'd love to ask them. All right, so I want to return to something I brought up during my opening remarks about the ALJs, the administrative law judges. As you know, the SEC announced in April that they had identified a control deficiency related to the separation of its enforcement and adjudicatory functions within its system for administrative adjudications. To quote an article from the Wall Street Journal, quote, it's the equivalent of a party in litigation having access to a judge's briefs from her law clerks, close quote. So given the scrutiny that the SEC has received over the use of their ALJs, I find this breach very concerning. Quickly, Director, can you assure members of this committee that the cases brought before an ALJ during that time of the breach were fair and fairly adjudicated?
So again, with respect to the breach, as soon as that breach was discovered, it was reported, it was publicly reported, and the matter's under investigation right now internally. But importantly, no enforcement division personnel were found to have access to those materials. It was simply that there was some permissions that allowed people to do so, but they were not accessed.
What gives you confidence? So has there been an investigation to determine that?
It's underway right now, Ranking Member.
So then how can you say that there was no breach? You actually don't know if the investigation's still going on.
Excuse me, I'm sorry to talk over you. In the announcement that the Commission made, again, it's not being handled by my division. It's being independently investigated, but in the preliminary announcement, it was indicated that the materials weren't accessed. The investigation is going to cover how this lapse happened in the first place.
Has the SEC Officer of Inspector General reviewed this incident?
I would direct you to the Office of Inspector General. I'm not aware of what they're looking at or not looking at.
Well, we will, I will be following up with some additional questions written as well, but underscores the importance of this, so I appreciate it. Thank you.